Please be seated. We are back on the record in the case of People versus Davion Thompson. The record should reflect the jury is not present at this time. And Mr. O'Farrell, I understand there's something you wish to place on the record in terms of your case. I understand you're going to be resting after your next witness. Let's cover your defendant's right to testify.
Thank you, Your Honor. My client not having a microphone, would you like me up there and have him use this microphone, Judge?
Yeah, that's fine.
Mr. Thompson, you understand that you have the right to testify or not testify, that is your constitutional privilege?
Yes.
And we have discussed that at length, have we not?
Correct.
And do you understand that that's your choice? I can give you my advice, but ultimately you have the choice to either testify and tell the jury your side of this or not testify, and the jury will be told your silence can't be used against you. Do you understand that?
Yes.
Do you have any question about your constitutional right?
No.
And I have advised you that in the circumstances of this case, it's my advice that you not testify. Is that correct?
Correct.
Have you made a decision about whether or not you wish to testify?
Yes, I would not like to testify.
Unless the court has anything else, Judge?
And Mr. Thompson, that decision is your own. Nobody's threatened you not to testify?
Correct.
Nobody's promised you not to testify?
No, sir.
All right, I'm satisfied your defendant understands his right to testify and is waiving at this time, Mr. O'Farrell.
Thank you, Your Honor.
Anything else you wish to place on the record, Mr. O'Farrell?
One other matter, Your Honor. I did review the jury instructions prepared by the court, and the only instruction that I would be requesting, and I understand it's not included at this point, would have been in regard to the cautionary instruction as far as an addict testimony, credibility. I don't think I can really ask for it, Judge, consistently with the court ruling that I could not go into questioning of Lisa Curtis regarding her use of opioid narcotics at the time of this offense going on.
Let me stop one moment, Mr. O'Farrell. I did not prevent you from going to that line of questioning. I prevented you going to the line of questioning where she got the drugs from. So there's a distinction there. I want to make sure that's clear for the record. I didn't stop you from questioning about her drug usage, but you can go ahead and continue though.
Okay. And the only question or the responses that came out in the drug usage was that she was using 4 different drugs, and I could not ask the detective whether those were opioids.
Because he's not qualified as an expert in this court's opinion. That's correct.
Okay. So, Judge, it's my position for consistency that the jury instructions prevent me from presenting that issue to the jury, although since I couldn't present it through evidence, I can understand the consistency of the court's ruling, if that's what it is.
Okay.
Thank you, Judge.
Any response, Mr. Fedor?
Thank you, Your Honor. The people would object to adding the addict informant or instructing the jury on the addict informant instruction. The court previously ruled that the instruction is not applicable to this case, ruling that as the court ruled during defendant's first trial, such an instruction is not applicable in this case because there is no evidence that Ms. Curtis has received consideration for her testimony, and there is other independent evidence to support the prosecution's theory that defendant killed the victim. And the evidence at trial was consistent with that ruling. So again, the people would object.
And the instructions to the jury have to be based upon the evidence presented in court. There was no evidence that the witness was an addict, nor was she an informant. And therefore, the instruction is inapplicable, and that's why I've decided not to give it. Anything else for the record, gentlemen?
No, Your Honor.
Mr. Fedor.
And Your Honor, just for the record, the people did request a aiding and abetting instruction. The reason for the instruction is there's concern that, as in the first trial, defense will raise an argument which the people do not believe is based on the evidence. However, it would be to address that argument that there was another suspect. The names that were thrown out in the first trial, as far as the suspects, were a man named Jamel, who was friends with the defendant, and also a Garland Davis, also friends with the defendant. If that's the argument, then basically attached to that is that the defendant was aiding and abetting those individuals. His DNA on the laser sight that was on the gun used.
Mr. Fedoruk, let me ask you a question. Are jury instructions based upon arguments of counsel, or are they based upon evidence presented during the trial?
Your Honor, and I agree with the
No,
court. It's based
what's
on
the
the
question
evidence.
though?
It's based on the evidence.
Okay, so when you talk about him raising an argument, you're asking me to give an instruction based upon his argument? That's what you said.
And correct, Your Honor.
So is that the standard for giving instructions, based upon argument of counsel or based upon evidence presented during trial?
Again, it's just based on the evidence.
Okay, so you're starting saying you want to give this instruction because of his argument is inapplicable. Would you agree with that?
I'll defer to the court.
No, I'm asking you the question. If you're saying you want me to give this instruction based upon his argument, is that the standard for giving an instruction to the jury?
No, Your Honor.
Okay, so do you have another basis for requesting this instruction? Because that one is inapplicable.
And it's solely based on addressing an argument.
Listen to my question. Do you have another basis for requesting that instruction other than his argument? Because we both agree that's the inapplicable standard. Do you have another standard that applies?
There's no other basis, Your Honor.
Okay, so that's why I'm not giving the instruction.
Thank you.
Anything else, gentlemen?
Nothing from the people.
No, Your Honor.
All right, let's bring the jury in. Please be seated. Morning, ladies and gentlemen. Prosecution having rested, Mr. O'Farrell, you may begin calling witnesses.
Thank you, Your Honor. This time I'd like to call Dr. Julie Howenstein.
Dr. Howenstein, come forward and be sworn by my clerk, please. Have a seat. You hold on one second, Mr. O'Farrell. You may proceed.
Thank you, Your Honor. Dr. Howenstein, would you, for the record, state your full name, please, and spell your last name?
My name is Julie Ann Howenstein, spelled Howenstine.
And Doctor, were you retained by me as far as consulting with me and perhaps providing testimony concerning DNA mixture?
Yes, I was.
And are you appearing today pursuant to my subpoena?
Yes, I am.
And could you briefly indicate to the jury your educational background?
My formal education includes a Bachelor of Science degree in microbiology, a Master of Science in Veterinary Science, and a doctorate in veterinary medicine, all from Michigan State University. That includes graduate level coursework in all of the sciences that are fundamental for forensic DNA biology.
And when I refer to you as doctor, you are also you have a doctorate in veterinary medicine, is that correct?
That is correct.
And as far as your professional experience, could you indicate that to the jury as well?
I was employed by the Michigan State Police Department in 1985 in their forensic biology section, then called serology. I was one of the 2 individuals that started their DNA lab and did the validation and research work to bring forensic DNA analysis to casework in Michigan.
And how long did you work for the Michigan State Police Crime Lab?
I was with the MSP for 25 years, and following my retirement, I went into work for Spokane Forensics LLC, which is a private consulting group in forensic science.
And specifically in regard to DNA analysis, were those part of your duties with the Michigan State Police throughout your career?
Yes, again, I was in on research and validation to begin casework starting in 1991. We started doing the validation in 1989. I practiced forensic biology, which includes both body fluid identification and DNA analysis, until I retired from there in 2010. And in the 10 years that I've been with Spokane Forensics, I continue to update my education by attending at least one professional association meeting or workshop annually, and also proficiency testing in both forensic body fluid identification and DNA interpretation.
Your Honor, I would offer Dr. Homenstein as an expert in biological and DNA analysis.
Mr. Fedora,
People will defer to the court.
she will be so recognized.
Thank you, Your Honor. And Doctor, when your office was contracted, or your firm was contracted by my office, was data provided to you for your analysis?
Yes,
And do you know where that came from?
largely it was from the Michigan State Police Department's Forensic Science Division's Lansing Laboratory. I'm sorry, came through Lansing for DNA analysis, but I believe came through Bridgeport Laboratory for the initial testing of samples.
Okay. And then were there additional data that you required as far as doing your analysis in this case, where you made the request to me?
Yes, I initially received a CD in October of last year that had all of the reports and included some of the police reports from Saginaw Police Department, I believe. And then I needed additional worksheets and I believe DNA charts that were subsequently provided by email.
And the email would have been from my office directly, as far as having been emailed to me from the Michigan State Police Crime Lab, is that correct?
Yes, all of my contact has been with your office.
Okay. And do you know, is there a policy where the lab will not provide data to you directly? It has to go through the attorney, or do you know that?
It's my understanding from communication with some of the people I still know in the Michigan State Police Department's Forensic Division that it is only provided to the investigating agency and the prosecutor's office, and has to be then provided to the defense office or to myself through the prosecutor's office.
And you mentioned people you still know at the lab. Do you know Nicole Graham?
I do.
Now, turning now to the evidence in this case, do you have experience in interpreting DNA mixture data then? Mixture
Yes,
data.
I've been doing that for about 30 years now.
And how do you know you are interpreting DNA mixture data correctly?
I follow the Scientific Working Group on DNA Analysis Methods, called SWIGDAM for short, which is a group of scientists from throughout the United States that are coordinated by the FBI. I follow guidelines that they publish. I also try to follow the protocol that the Michigan State Police Department established while I was still there doing DNA analysis and have updated subsequently. And I've also annually attended, as I said, continuing education on workshops for DNA analysis methods and interpretation methods. That includes 32 hours of online education in the use of probabilistic genotyping, which is the interpretation for DNA analysis of mixtures.
If a person cannot be excluded as a DNA donor to a mixture, how do you give weight to this information?
In a mixture sample, if you can't delineate that a certain individual is by far the major DNA donor, the scientific approach that's accepted at present is using a likelihood ratio calculation, which is based on software that uses a probabilistic genotyping model.
And there's a short term for the likelihood ratio, is that LRs?
Yes, and probabilistic genotyping is PG.
And do you understand how LRs are calculated?
Yes, I do.
And are you familiar with the, well, it's called star mix, or at least that's the way I pronounce it. It's capital STRM and then IX.
Yes, StarMix is a computer program that, again, uses the probabilistic or PG genotyping model to determine what's called the likelihood ratio from genetic data that indicates mixtures of DNA contributors.
So would that be a supplement as far as a software program to do the likelihood ratio analysis?
I'm not sure the exact definition of the word supplement, but what it is at the end of running the DNA analysis where the analyst will do a visual comparison of the chart, which is called an electropherogram that is generated by their instrument, the genetic analyzer, and determine whether someone can be obviously excluded from a mixture. If they cannot obviously exclude them, and it is mixed data, so you can't say that this all came from one individual. The STR mix is the computer program that's used to give weight to that association. You're saying they cannot be excluded, but how likely is it that anyone could not be excluded? So you use STR mix software to give you the likelihood ratio that says it's more likely or less likely that this person is included in the mixture.
Thank you. Is star mix then generally accepted within the forensic biology community?
Yes, it is. There is some debate within the community as to how to standardize its use and how to testify to what the results mean, because it's not what we consider expert software where there is no human involvement. Pretty much the data goes from a genetic analyzer to the software, and the computer tells you everything based on everything that's in the data. With STR mix, the analyst, in this case I believe it was Nicole Graham, tells the computer program what assumptions to make, largely how many contributors they think could be in this mixture, and then also testifies to what the end result means.
Are you aware of any guidelines available to standardize the use of software like star mix?
Yes, that SWIGDAM group that I mentioned previously put out guidelines for reporting likelihood ratios in forensic data mixtures back in July of 2018, I believe.
And are you familiar with the concept of DNA transfer?
Yes,
Is it true that DNA can transfer from a person to an object and then from that object to another?
yes,
For example, skin cells can transfer from my hands to a table, is that correct?
yes, that would be called a primary transfer.
And if you came by that same table and put your hands on it, some of my DNA could transfer to your hands, is that correct?
It is, and that is called a secondary transfer.
If you then went to a door and opened it, you could leave some of my DNA on the door handle, is that correct?
That is possible. That's called a tertiary transfer. So each time the DNA moves from one source to the other, you increase the adjective for the transfer.
Is it true that some people leave more DNA than others?
Yes, there have been a whole lot of studies published on what they call shedder versus non-shedder arguments, and the overall consensus seems to be that some individuals do shed more DNA skin cells just naturally. However, it's also influenced by hygiene, how often you wash your hands or your body, and friction, how you touch something, how much pressure you applied, and how much sliding along the surface causing friction. All of those increase the amount of DNA transfer. So there have also been studies that among a single individual tested several times, you get variable amounts of DNA that's transferred to an object.
Does the major profile refer to the criminal contributor who has more DNA than the other persons in a mixture sample?
Yes, if you can determine that, which they basically say has to be like in a two-person mixture, 60 to 70% or more DNA coming from one person, who is then called the major donor, and the person that contributed 30 or less is the minor donor. And in multiple person mixtures, again, if you have a single person who seems to have contributed most of the DNA above, say, the 70% rule, then that's the major donor, and you have multiple minor donors.
Can you tell if a major DNA profile donor was a person who touched an item last?
No.
Can you explain why that is?
Again, since about the late 1990s, about in 1997, the first researchers were seeing extra DNA in what they considered to be a single source sample. So they were picking up what they think are secondary transfers. People had touched someone else's clothing or someone's skin, and they picked up their DNA. So they started running a lot of experiments. We've been running them now, as I say, for about 20 years, and it's still ongoing because we're still trying to put weight to, these numbers, whether or not someone who most recently touched it left the most DNA or not, and getting surprising results. People who had just touched something for an extended period because they may be non-shedders, or they had just washed their hands extensively, or something happened. We don't even pick them up, but we pick up someone else's DNA that was on their hands. So we know we cannot make a statement that because you're the person who has the most DNA on something, you touched it last, you touched it the longest, you touched it within a day or whatever, because again, unless DNA will persist for decades or longer, they're doing DNA on archived samples now that are 50 plus years old. It'll stay there unless it's exposed to things that will break it down or physically wiped away, washed away. So you can't make statements how the DNA got there, when it got there, specifically unless you have a body fluid that you've identified and the major donor is there, because body fluids contain more DNA per volume than your average swabbing of a surface that has just skin cells that have been shed.
So when you mention body fluid DNA, would that be like when you test for the paternity test, where you take fluids from a baby, a mother, and a father? Is that what you're talking about?
Well, in forensics, we generally test for semen, blood, saliva. Those are the three that have cartridge tests, kind of like pregnancy tests. And you can look microscopically and determine vomitus or fecal material. So that's what I'm talking about, body fluids, substances that are secreted from the body. Nasal secretions have a lot of DNA, for example. So if you sneeze or if you wipe your nose on your hand and then you touch something, you're usually transferring quite a lot of DNA.
So in terms of mixture data, what DNA testing can tell you that if a person is profiled in the mixture, they can't be excluded from having provided DNA to that object that's being tested. Is that correct?
Yes, if we cannot exclude you based on the data and it is a mixture, then that's the statement. We're not saying you're absolutely there in DNA speak, because again, depending on the type of mixture, it's either very clear that you could well be a contributor or that you are not. If you cannot be excluded, then we have to simply state that and try to give you some statistical likelihood of whether or not you are indeed a contributor to that mixture.
So if you are a contributor, though, then could you say how that contribution got to the object?
No, again, unless it's a case where you, for example, in sexual assault, identified that you have the presence of semen and the mixture is consistent with coming from the alleged victim and the proposed semen donor. In that case, we make an assumption that you are the semen donor, but or if it's identified as saliva by the testing or blood. Other than that, we make the community in general, when I say we, the forensic biology community, would say that you can't be excluded from the mixture as a donor, and the source of your DNA is unidentified.
Doctor, you had mentioned the reports and some of the evidence in this case. The DNA results from the analysis of a laser light site item. Well, did you examine that from the reports and the information provided to you?
Yes, I had a report and worksheets that identified swabs of a laser site as item 3E, as in egg. And that was the only sample that proceeded for DNA analysis as far as I know. And that one gave results that was a mixture of at least 3 individuals.
And that would have been the worksheets of Nicole Graham in this case?
Yes,
So you utilized the same data that she utilized?
yes.
And did you see anything improper or any mistake that she had made in terms of her analysis of the DNA mixture?
No, I did not.
Now, did she include in the worksheets, did it have data in terms of the amount of the sample associated with this gun site?
Yes, one of the steps of the DNA analysis is to quantitate how much DNA there's present per volume in what's called the extract from the sample. So the gun site was swabbed, and then the swabs are cut off into a tube, and liquid is added with buffers and enzymes that'll break open cells and release DNA. And once you've got it released and cleaned up, you put it into an instrument that tells you the approximate, it's a qualitative, somewhat quantitative system that tells you how much DNA per volume of extract is present. Then you can multiply that by the total volume of the extract and figure out how much DNA is in the sample.
Now, in your analysis of that, did you come up with I guess a quantitative analysis of the amount of DNA actually associated with the workup here?
Yes, I did.
What would that be?
I calculated 0.67 nanograms of DNA, of male DNA, in the extract from item 3E, which was identified as swabs of a laser site.
And is there any way to determine how many cells that would be in terms of a DNA sample?
0.67 nanograms is 670 picograms. There's 1,000 picograms in every nanogram. These are very small quantities, obviously, but the cells have what's a skin cell, for example, a non-sperm or egg cell will have about 6 picograms of DNA per cell. So 670 is about 111 or 112 cells, skin cells.
Does the smaller size of the sample have any correlation to the source as to whether it could be from touch or secondary transfer or even tertiary transfer?
It does, because again, like I said, many studies being done and published trying to see how much DNA you recover from secondary or tertiary transfers, or even how much DNA you recover on a certain substrate on surface, whether it's fabric or the top of the table or a gun sight. A lot of testing being done and reported. I only know of one that came out of Australia back in 2010 where they actually quantitated secondary transfer. But the more you experience looking at DNA analysis and the quantities that you extract from certain samples, you kind of formulate an opinion anyway of a direct contact sample that is skin cells, for example, giving you somewhere in the area of 1 to 10 nanograms of DNA. A secondary transfer giving you less than 1 generally. And a tertiary transfer giving you, again, it wasn't quantitated, I don't believe. Instead, they were looking at how many genetic markers they were developing when they went on to do the final DNA analysis of their samples, but it was much less than secondary transfer. So you form an opinion, and as I said, skin cells then, if someone's touched something, you're looking at contact DNA that they've worn it or they've touched it versus sneezed on it, or semen's present, or blood is present, or saliva is present. And when you have body fluids, now you're looking at tens of nanograms. You're looking, usually semen will have 100 nanograms of DNA when it's extracted as a small quantity sampling, because there's a lot of cellular material there. And saliva will have more like the 1 to 10 nanograms, again, like skin contact, if someone absolutely did direct primary transfers. So we just get a feeling for that, but there are no probability statements as to how much more likely something is a secondary transfer versus a primary.
Okay. So doctor, we have the object, the site, where the data shows there were 3 donors or contributors of DNA.
Yes, it indicates at least 3.
Okay. And it does not exclude Davion Thompson as a contributor.
That is correct.
It's not probative as to whether or not he ever actually touched the object?
Again, the quantity being less than 1 nanogram, 0.67, indicates that it could be either a primary transfer from some having touched it or a possible secondary transfer. So again, just the opinions that are formed within the community from experience, as well as these studies that are still ongoing, trying to get an even better feel for how much DNA can be transferred. They have had secondary transfers that were up around 5 nanograms, and that may be because someone had sneezed on their hand before they touched it. So now they started with what we call a load, a lot of DNA that is now moved to something that moves somewhere else. But again, that's what's indicated, secondary transfer or direct contact.
And doctor, if someone, strike that if I may. If I asked to borrow your handkerchief for a moment, And then I placed that on my desk, or used it to wipe something, not my nose, but wipe something. Could your handkerchief transfer your DNA to an object?
Absolutely.
So something worn by someone can transfer their DNA.
If it's, yes, if it's repeatedly worn, again, the load is greater because the more you have something in contact with your skin and the longer it's in contact and the friction from rubbing your skin or whatever pressure, if it's tight, those all increase the amount of DNA that's transferred. And once you have it on clothing or on any surface, it can move to another surface if they come into contact.
Thank you, Doctor. I have no further questions.
Questions, Mr. Fedor?
Thank you, Your Honor. Morning again,
Good morning.
Doctor. Now, so just to clarify, now you do agree that StarMex is generally accepted in the scientific community, correct?
Yes, it is.
And you do agree with the application in this case as far as how Ms. Graham applied StarMex.
I do.
And as far as the quantity of DNA that was taken from the laser site that Mr. O'Farrell was discussing with you, considering that quantity, that sample was suitable for testing through StarMex, correct?
Yes, while it is a small quantity, again, that, could come from a very 110 cells, which is not many because we shed hundreds of thousands a day. Anything above 50 picograms or 0.05 total nanograms gives us pretty good DNA results these days. The sensitivity of the polymerase chain reaction DNA analysis is very extreme.
So again, the sample taken in this case, it was suitable for testing.
Absolutely a suitable sample, and
Okay, thank you.
the protocol was followed and the results are reliable.
Thank you. And again, so obviously, as you stated, you don't disagree with the results in this case. You agree with the results that Ms. Graham came up with.
Yes, I do.
All right. So Ms. Graham stated the likelihood ratio with respect to the sample taken from the defendant, Mr. Thompson, and the sample taken from the laser site. Ms. Graham stated that likelihood ratio in the following language. It is at least 1.0 octillion times more likely if the observed DNA profile from the swabs of the laser site originated from Davion Thompson and two unrelated unknown contributors than if the data originated from three unrelated unknown individuals. Do you agree with that likelihood ratio?
From the data I saw and the worksheets that came from the application of the software, yes, I agree with that number.
Okay. And are you familiar with the number 1.0 octillion?
I know it's 1 times 10 to the 27th power, so a 1 with 27 zeros behind it.
Okay. And you agree with the conclusion that Ms. Graham stated in her report. There is very strong support that the defendant, Mr. Thompson, is a contributor to the DNA profile developed from the swabs of the laser site. Do you agree with that?
Yes, I do.
Now, you said something about Sturmix and there being no human involvement. Would you agree in this particular case, the profiles lended themselves to visual comparison?
I didn't state that StarMix has no human involvement. I said it is not an expert system, and an expert system does not have human involvement. So StarMix, as it was applied in this case, had Ms. Graham or perhaps someone else who was running the software analysis on her behalf told the computer there were 3 people present, 3 donors to the mixture, and they set parameters for, you know, what it will include or exclude as what's called drop in or drop out, or stutter percentages and peak height ratios that are, they set all of this into the instrumentation, and then they get the data. But I believe your question is, was it a sample that was appropriate to apply StarMix to, and was it used appropriately? And I would say yes.
And could also a visual comparison have been done?
Absolutely. That's done before you determine whether or not you will apply the software to get your statistical calculation to give weight to an association that someone can't be excluded.
Did you yourself do a visual comparison?
I did.
And was that consistent with the Sturmix results?
It absolutely was.
And just to clarify, when you're talking about DNA transfer, when you're talking about bodily fluids, you know, the fluids you had discussed, would you agree that there's a higher rate of transfer with respect to those bodily fluids than skin cells? Is that correct?
Depends on whether it's a primary transfer or beyond, secondary, tertiary. It depends on whether it's a dried sample or not. For example, body fluids that have dried down tend to, on fabric, for example, tend to flake off, and so you have less and less, and there's a lot of parameter or variables involved. But in general, the consensus is that you usually get more DNA transferred from a body fluid stain, dry or otherwise, on secondary transfer. And you absolutely, for a direct deposit, have more for a primary transfer when someone has spit onto a table or something versus having touched it.
Now, just going back to the results that Ms. Graham came up with. So again, you agree there was 3, you agree with her findings that she found there's 3 contributors to the laser site DNA sample. You agree with that?
I agree that there are at least 3 for the purpose of applying the software in the mixture. And the reason I say that is because to decide that you have at least 3 donors in a mixture, usually we all get 1 type from mom and 1 type from dad in our genetic information when we're conceived. So at each of these sites that we're testing, and in this particular kit that's used, they test 23 different sites, you see for an individual 1 or 2 sized fragments of DNA. If there is only 1, it's usually because mom and dad had the same size piece, and so you only get 1 peak. And if they had different size pieces, then you're getting 2. So to know that there's at least 3, you have to have 5, because 2 from one person, that's 1, 2 from another, that's 2, and 1 extra one comes from somebody else, that's the 3rd person. However, you don't know that you don't have 5 donors there, and each of them is what's called homozygous. They only have 1 peak there because mom and dad's pieces were the same, or other very rare experiences. So we say at least 3 when we see more than 5 or more. It would have to be 5 or 6, because if it went up to 7, then they say there's at least 4. So in this case, at least 3 people, but you do have to, again, look at the whole picture. Don't see the tree for the forest, and decide that, well, we're going to say there's 3 donors in here, so the software can model what would be the likelihood that you'd have this person as one of 3 donors. And I agree with Ms. Graham's interpretation of the mixture to call 3 donors and use it for STR mix.
Okay. And you also did a visual analysis and that was consistent with her finding.
Yes,
All right. And so Ms. Graham found there was one 93% contributor, one 5% contributor, and then one 2% contributor. Is that correct?
STR mix told her that. It puts out the percentage of donors when you say there are 3 people here.
Okay. And you don't disagree with those findings, correct?
No, when you look at the chart, the electropherogram, there is a major donor, in my opinion, that was that 93% quantity donor to that mixture.
Okay.
And then there's at
And so-
least 2 additional minor donors.
And so the major donor in this particular case, the finding by Ms. Graham was that defendant's DNA sample, that made up the major donor. Is that correct?
Yes, all of the genetic information that you would attribute to that 93% major donor in this mixture was consistent with the known sample of Mr. Thompson.
Okay. And so given all that, the results that Ms. Graham came up with and that Sturmix came up with, is that consistent with the theory that the defendant, Mr. Thompson, actually handled the laser site?
It's consistent with his DNA being present on the laser site.
That's
He
fine.
may
Thank
not
you.
have handled it.
Thank you.
Anything else, Mr. O'Farrell?
Just one. Is it fair to say then that the prosecutors leaped to a conclusion that Mr. Thompson handled the object goes beyond the conclusion that can be drawn from science that his DNA contributed to the object in a major way?
To be fair, I would say that his assumption is one of 2 possibilities, that either he did handle it or it was transferred by secondary transfer.
And that's what the science shows.
That is what the science shows.
Thank you.
Anything else, Mr. Fedoric?
No, Your Honor.
You may step down, Doctor.
Your Honor, may I be excused from the court?
Yes. you may be
Thank you.
excused. Call your next witness, Mr. O'Farrell.
Your Honor, we have no further witnesses. We would rest.
And the rebuttal witnesses, Mr. Fedoric.
No, Your Honor.
Mr. Fedoric, you may begin with your closing remarks.
And Your Honor, before I do, we moved the monitor to accommodate Ms. Hohenstein's testimony. Do you mind if we have that moved back?
That's fine.
And I don't know if I can do it, if the tech people can help me.
Tell you what, let's take a break so we can get the courtroom set up for how the lawyers want to have it done, so they're not doing it midstream and tripping over you and themselves. Go with my law clerk, please. The jury is not present at this time. Anything else for the record, Mr. Fedoric?
No, Your Honor.
Mr. O'Farrell?
No, Your Honor.
Mr. Fedoric, we'll take a break, allow you to have the monitor moved and maybe even the podium moved for both of you gentlemen to do your closing argument, and also test any equipment that you want to have used during your closing argument to make sure that it's working properly at this point in time. So we'll take a short recess to allow you to do so.
Thank you.
Please be seated. Back on the record in the case of People versus Davion Thompson. Counsel prepared to proceed with their closing remarks.
Yes, Your Honor.
Mr. O'Farrell?
Your Honor, I just have a question about the public aspect. Are we going to use the table that's up by the jury, and is that still in camera as far as being public, or are we going to use the podium?
Which do you prefer to use?
The podium has all the camera angles, Judge, but
Or how do I put this? The public will be able to hear you one way or another. My concern is that we conduct the trial according to how you are most comfortable conducting your trial. So whether you stand at the podium or at the table, the public will be able to hear you. And it would depend on which one you stand at, they may be able to see you. But the important thing in this court's opinion is that the jury is able to hear and see you.
okay. I understand, Judge.
All right, we can bring the jury back in. Please be seated. Mr. Fedoruk, you may begin with your closing remarks.
Davion Thompson shot and killed Antonio Parham out of revenge, out of a perception, a belief that Antonio had killed Davion's friend, close friend, Brandon Pennywell. That's what the evidence in this trial showed. There is evidence as to his motive. The testimony from Ms. Curtis, from detectives regarding Brandon's murder. Lisa Curtis was cooperating in that homicide investigation. That the defendant, Mr. Thompson, is not cooperating. Thompson, once he had enough information as to who he believed was the killer, he wanted the guy dead. He wanted Parham dead. That's what the evidence showed. Now, there was the defendant's own statement to Ms. Curtis admitting to killing Mr. Parham. The defendant admitting that he got rid of the murder weapon, the gun, .40 caliber pistol. That he got rid of the gun so that it couldn't be found. And then there's other evidence. You heard the forensic evidence, the ballistics, you had the bullets in the casings that matched the murder weapon, 40 caliber. You heard evidence as far as the DNA evidence of the laser sight that Thompson put on the gun. You heard the cell phone data, location evidence from Detective Kahn that put Thompson in the area of the murder on January 27, 2018, at the time of the murder, around 12:30 in the afternoon. Now I'm going to take you back to how this kind of all got started. Now, you heard some evidence about some text messages that Curtis sent to one of the detectives. And in those text messages, there was some information about who Brandon's killer was. Someone named Tone, that we learned is Antonio Parham. This was information that Thompson was familiar with and speaking to people he knew on the streets. This was information that Lisa Curtis had learned from people in the streets, Thompson, and it was Lisa Curtis pass it on to the detectives. Then we saw some evidence as far as some text messaging. And this gave us a little bit more information. So on January 21st, the defendant had actually made contact with Parham after not having contact since September of the previous year. Just out of the blue, contacted Antonio. That was January 21st. Now, just 2 days before that, either a day, 2 days, Ms. Curtis wasn't clear on the exact date that he gave Thompson the gun, but she did give him the gun on either the 19th or the 20th. The defendant claiming that he needed it for protection. So at this point, Thompson's got the gun, he's contacting Parham, sets up something to meet to smoke some weed. Asks about an address, doesn't get it. He gets a rough location of where Parham is. They agree for Thompson to go and smoke some weed with Parham, but the defendant doesn't show. He ultimately tells Sergeant Jacobs that he just lied to him that he's going to show up. He didn't actually intend to. So then the next day, Parham sends him a text message back and says, why didn't you show? And then there's a little bit of conversation. And then that conversation ends with some tentative plans that they'll meet up in a couple of days. That's January 22nd. January 26th, defendant goes into the hospital, goes to the ER for some issues as far as shortness of breath, that kind of thing. Now, he's discharged from the hospital, and that was January 25th. He went to the hospital. January 26th, around 2 a.m., he's discharged from the hospital. Now, he gets his hands on some masks from the hospital. Doctor didn't recommend that he have any masks, didn't give him any, but the defendant goes and manages to get him some. And then he leaves the hospital. Now, the next day, Ms. Curtis has contact with him on the very same phone that she's had contact with him for the last couple of months. She's had contact with him on ever since the defendant got that phone from Ms. Curtis's son, Brandon. Then we get to the January 27th. So again, there's a tentative agreement that they'd smoke weed together, Thompson and Parham. So Parham reaches out to the defendant on the 27th, and then they set something up. Defendant's out driving, texting with Parham. Eventually, he gets the address of where Parham is, drives into his driveway. Parham comes up, approaches the driver's side of the Dodge Charger the defendant's driving. And once Parham is right in front of Thompson, Thompson fires multiple shots right at Parham. Nine total shots enter Mr. Parham and eventually kill him. Now I'm going to get into the evidence a little bit here. So first thing is there's a Dodge Charger the defendant got his hands on to help him accomplish this murder. Now the testimony was that Ms. Curtis gave the defendant the car on the 22nd. And the defendant acknowledged as such when he spoke to the sergeant. He told Sergeant Jacobs that he asked for the car because he had an interview at Jimmy John's. Now, he told Ms. Curtis that he needed the car for that interview. However, once he gets the car, he doesn't bring it back. He tells Sergeant Jacobs that he brought it back, but he said he didn't go to the interview. But that's what he claims he had the car for. He claims that, oh, there's too many people there. Oh, I had a sore stomach. I had diarrhea. So I didn't want to hang around. So let me get it straight. He asked Curtis for the car, got it for that specific purpose, and then he just brought it back after not even going to the interview. No, that's not why he got the car. He got the car to help him kill Parham. No, and part of his cover here, he claimed that, well, he was sick with an upset stomach. He went to the hospital on the 26th. It was shortness of breath, difficulty breathing, chest pains, fever, sore throat, nothing about an upset stomach, diarrhea. Curtis kept calling about the car after she had given it to him on the 22nd. Called him daily, called him on the 26th after he was out of the hospital. And Mr. Thompson never indicated he was going to give the car back. And she was okay with that, but she was concerned about Thompson and the car. Now, following the murder, the detectives contacted Curtis because they had the information that her car was used in the murder. And what does Curtis say? Davion's got the car. Okay, and this is her first contact with the detectives. So she doesn't have the opportunity to fabricate something or anything like that. No opportunity to cover for Thompson. She says Thompson's got the car. Because that's who had the car. Thompson had it because she had given it to him and she had not gotten it back. When Officer Hill found the car, it's a strong odor of marijuana coming from the car. Windows were closed, yet he could still smell it. What was Thompson doing? He's arranging to get together with Parham, smoke weed. He didn't deny that in his interview with Sergeant Jacobs, that he even admitted at some point he was trying to get together with Parham to smoke weed. So the evidence tells you Thompson and nobody else had the Charger on the day of the homicide, January 27, 2018. Now let's go move over to the cell phone. So Brandon Pennywell, before he died, gave his phone to Thompson. And that was the contact number that Lisa Curtis continually used to get a hold of Thompson. Now, after the homicide, the phone just suddenly shut off. Service is canceled. Less than an hour after somewhere around an hour after the homicide is shut off. It's gone. Police can't trace it. Thompson got rid of it. Why? Because he didn't want to be tracked down. Because he knew they could trace the phone to him. He didn't leave it at the hospital. You heard the doctor. She didn't notice anything missing after Thompson left. Curtis talked to Thompson after Thompson left the hospital. She talked to him on that phone, from that phone number. Now, I'm just going to play some excerpts from the interview, and we're going to go over the text messages that were found in Parham's phone. And you saw Mr. Parham holding a cell phone when Saginaw Police Department first responded, and they got that cell phone from Mr. Parham and extracted those messages. So you saw that. I'm just going to go over those two things, just point out the consistencies. Now, first, I'm going to play. So, when Sergeant Jacobs was speaking to the defendant discussed an incident that happened on the 16th. He said the 16th, 17th were his exact words. The question was, when did you last see or last contact? I've lost last contact. And his answer was the 16th, 17th. Now, I'm just going to play that excerpt for you now.
When was the last time that you saw him? Way back in September this past year? Last year? Where did you see him at? Which one? Court Street?
Now, that's the last time that Thompson said he saw Parham. And then we'll get into the last time he had contact with Parham in just a minute.
You guys just happen to pass each other? You guys say anything to each other, anything like that? I mean, you guys are cordial. You know, like when you see each other, it's like, hey, bud, what's going on? You know, type thing. You know, catch up for a minute. All right. Did you have other kids? Were you guys like Facebook friends and stuff like that? Instagram, all the, you know, all that other stuff. I don't know, Twitter, whatever. Just Facebook. Okay. Yeah, I don't do any of that stuff. I guess I'm too old for that mess. You guys have each other's cell phone numbers or anything like that? You didn't know? I mean, you guys weren't that tight where you had his cell phone number, he didn't have your cell phone number? You guys didn't call each other out, nothing like that? No? Now, you guys became Facebook friends, that's just, you know, you just friend requested, you know, people that you know, but There wasn't like, you guys weren't communicating on Facebook to each other or anything like that, back and forth?
Yeah, I talked to him not too long ago. It wasn't like, it was quick conversation. Like, he used to hit me up after his, to smoke.
So he asked you to smoke some weed? Is that what you're getting at, weed, not crack?
Yeah.
You need to find out not smoking crack, nothing like that, just some weed, right? Okay. How long ago was that that he hit you up for that?
I think like last time I actually talked to him, like, earlier this month. It's
Still January, the 30th.
I talked to him like 16,
16
17.
or 17. What makes you remember those two dates? That was the last time? You're pretty good with like remembering dates. Like for me, if somebody asked me if I, talked to somebody, I'd just be like, yeah, I talked to them a couple weeks ago. I wouldn't be able to like pinpoint the dates. You know what I mean? You're good with that? So it was like the 16th, 17th. Nothing out of those two dates makes you specifically remember that. It's just, you're just good with that. Okay. All right. And was it like during the daytime, afternoon, evening, if you remember? Afternoon?
Midday.
Like midday? Okay. And does he contact you or do you hit him up? He hit you up? What specifically did he say? You remember the date, but you can't remember what the conversation was?
Say that again? Well, like, what's up, cuz?
Okay. So he hit you up, what's up, cuz, and then you come back at him, what? Okay. So you guys are just kind of small talking and, chit-chatting, and how does this weed thing come about? What does he say to you as far as that?
Still smoke, bro. Smoke.
So he's just asking if you still fire up, smoke weed. You guys like make a plan to smoke together or what?
He wanted me to come, Bloomfield and smoke.
Why don't you go to Bloomfield next month? Is that what you said? Like I said, you got to speak up a little bit.
No, I said he wanted me to come, he asked me to come to Bloomfield and smoke with him.
On that day? Okay. And what was your reply to that?
I said, yeah, I'll be lying to people. When people ask me to do something, I'll be like, yeah, all right, I'm gonna come out there. Like I think I was sick then though.
Okay.
When I was talking, so it was never.
It was starting to build up there. Your sickness was starting to build up already at that point? And you were really feeling it?
Even if I wasn't sick, I'll probably still be like, all right, yeah, here I come. I'll be telling everybody that I'll be just lying to people saying I come.
So basically, at this, so he's expecting you, but you're like, you formulated the plan because you really didn't want to like tell him no or nothing like that. You just lied to him saying that, yeah, I'll be out there, but you knew in your mind you weren't going to go out there, right?
Right.
Okay. All right. And that's kind of like your thing to avoid, having to, let's say hurt somebody's feelings or, avoid having to get into like a big old confrontation. Oh, come on out. Are you a puss or, whatever. You just, make shit up to lie to people in order to just not have to deal with, the issue at hand, right? Okay, fair enough. So he's expecting you don't show up. Does he hit you back up and say, hey, man, what's going on? Why are you out here? Never hit you up again? Just, you guys didn't have any contact after that? Not through Facebook, not texting, no calls, nothing? Why out of the blue, if you guys don't really hang out or anything like that, why out of the blue did he just hit you up to go smoke some weed if you hadn't seen him since last September? You don't know? Did you find it kind of strange or odd or anything like that? Was that?
I said, no, people always be hitting me about the news.
A lot of people hit you up out of the blue? And this, you just figured he just wanted to chill out and smoke some weed with you? But you lied and said, yeah, I'll be there, but never showed up and you never heard from him again? Is that correct? Okay.
Right, so that's from the interview that you heard during the trial. Now, again, the defendant gives the date of 16th to 17th. He's describing one incident in one day. And he's saying that he didn't talk to him again after that one day that he says it was the 16th to 17th. You also notice when he's asked what day that was, he started out saying 20, stopped himself, and they came up with the 16th and 17th. Everything he's talking about lines up with these text messages from January 21st. And again, this is where he got the gun from Curtis. He gave it to him on the 20th and 19th. He doesn't have the car yet. I'm going to go through those with you. You see on the screen or the overhead, these are the text messages between Parham and the number associated with Thompson. And you'll see the first communication, that's January 21st, about 11:06. Thompson is saying it's early afternoon in his interview. And this is the first message. This is initiated by Thompson. Now keep in mind, last time that Thompson has seen Parham back in September 2017. It's been a few months. He's hitting him up out of the blue. And that's the message, just because. Parham responds shortly thereafter. Basically, now, I don't want to spend my time going through all of these, but I just want you to get the gist of what's going on in these communications. Further up, we have, again, some kind of evidence of that they're trying to get together to smoke weed, and the defendant's inquiring about where Parham is. All right, so here we have 11:09, so that's about 2-3 minutes after this is initiated. And this is a message from, and sorry, I'm going to be fighting with this document camera, but this is a message that is from the number associated with the defendant. And it reads, where the hell we can link and blow and shit you say into Bloomy or still be west. Again, this is from the number associated with Thompson. So at this point, he's inquiring about Bloomy. Remember those text messages that Curtis sent to the detectives? There's stuff in there about Bloomy, about Bloomfield, about Parham's family living in Bloomfield. So this is related to that. At this point, Thompson may be trying to figure out where Parham is at this point, or he may know, but he doesn't want to let on to Parham. Because obviously, if Parham hasn't told him where he lives, and Thompson's trying to kill him, he's not going to tell him. Thompson's not going to let Parham know what he knows. But at any rate, it's possible here that Thompson's kind of trying to probe in further, find an exact address.
And then this is about 11:12 a.m., so just a few minutes after. I'm gonna hit you in a second. Let me get ready and shit. If not, we a link on West, cuz what part of the West you be on? Well, stay on. And then it kind of progresses. Again, there's a lot of discussion about smoking marijuana, and then we get up kind of to the end. This is from the number associated with Thompson. He says, finna get out in a sec. I'm gonna call you, we can blow. And then the next message from Parham is, aight. Now we go to the next day, the 22nd. This is a text message from Parham. And that's to the number associated with the defendant. And you can see what Parham's saying there, this me cuz. Sorry. Wrong page, sorry. Cuz, what happened to you last night? That's Thompson not showing. And then you see the conversation going on from there. Thompson inquires again about where Parham is residing. And Parham eventually says, again, South Bond, right by Mackinac. So again, Thompson told Sergeant Jacobs the last conversation was that 16th or 17th is actually the 21st. That's not true. We had this conversation on the 22nd. Now, the next line, before they stop communicating. Okay, I'm finna try to get in these wheels we can blow. And again, going back to what happened on the 22nd, that's the day that Thompson got the car from Lisa Curtis. All right, so that brings us to the 27th. At this point, Davion Thompson has charges. So he has his car that he can get to Mr. Parham. He has a gun. Someone else's gun is not traceable to him. He has that .40 caliber Smith & Wesson. So at this point, he's ready to go. Now, this is when he gets the text message from Parham about meeting up to smoke weed. So as you can see, this is from Parham to the number associated with Thompson. About 10:50 in the morning, January 27th. This is about the time that that Parham is talking to Bell. Bell might be at the house already or he's on his way. We heard testimony about that they were looking to smoke some marijuana at that point. Some testimony from Mr. Bell, Ramon Bell, that the defendant had been texting somebody. So what's up, Lil Cuz? That's what you get from Parham. Thompson responds, just bypass the expletives, but what's up, cousin, is what he said. And I remember, I'll take you back to that interview with Sergeant Jacobs. And he asked about that communication on the 21st. And he asked Thompson, how did that go? Thompson's response was, I said, what's up, cuz? To that effect. That's completely consistent with what we have here. Now I'm just going to go ahead here. There's communications again about meeting up to smoke some weed. All right, this is a message from the number associated with Thompson. And this is about 11 o'clock, about 10 minutes later. And they've been texting back and forth at this point regularly. So again, this is from the number associated with Thompson. And he says, okay, just LMK, cuz I'll slide, flow, match it, don't matter, I'm in wheel. Matches up perfect with what we saw on the 22nd. We're talking about having wheels, so they can get together. Gets the car from Curtis, 27th, says, I've got wheels. The same person. This is Mr. Thompson. Now, still up to here, Thompson doesn't have an exact address in any of these messages of where Parham is. So we go on. This is a message from Thompson. This is about 11:05. He asks for the address, and he says, okay, what's the address? Because I only know west like that, only know Maine, and then you'll see the next message carried on from there. Main Street. So he says he only knows the main street. And then there's continued communication between the two until we get down to $12:28. Sorry, 12:25. So we have this message from the phone associated with Thompson. Come outside, cuz. At this point, Thompson either in the driveway or he's close to the driveway. Parham's response is, I'm outside. Parham's waiting in the driveway with Bell sitting in the car. And then the very last message, still at 1:25 in the afternoon, is from Parham again, when he asks what you win. So it's clear when we compare those two things, we compare all the evidence, it's Thompson who's communicating with Parham through these text messages. Look at all the consistencies within the substance of these messages that I just mentioned. Also, another thing is the frequent association of Thompson to Parham with the term cuz. He continually refers to Parham as cuz on the 21st and the 27th. Now, another thing, let's go back to when Officer Hill locates the Charger. Again, what did we hear from Officer Hill? And this is less than an hour after the homicide. And he notices the car has observations that are consistent with the car being just driven. Hood's warm. Tires are wet, debris on them. It's like it had been driven recently. And then there's that heavy smell, marijuana coming from the car. And again, what is the defendant doing here? This is all about he's into getting weed for Parham. Although that's not the intent on this particular day on January 27th. And it wasn't the intent on the 21st. This is all set up to get to Parham, to shoot him, to kill him. We had additional evidence connecting Thompson to that phone. You heard the testimony from Detective Kahn just yesterday. And he testified to what he saw in the phone records. He saw all those phone calls on the 26th after Thompson got out of the hospital. All those phone calls on the 27th, on the day of the homicide. Those were all calls that the caller made from that phone. And all of those calls, except for one, were all made to the same people that calls had been made to on that phone for the last 2 months. And not only that, the caller on this, the user of this phone, had been calling the same numbers on that phone for the last 2 months. The same person who was using that phone on January 27th was the same person who was using that phone on December 1st. It was the same person who was using the phone every day in between. It was the same person who was using the phone when Brandon Pennywell gave that person that phone. Davion Thompson was the one using that phone. Now, there's the whole thing where the defendant told Sergeant Jacobs, well, I've been in bed the past 2 days because he's sick. Now, maybe he got those masks from the hospital so that he could show people that he was sick. So maybe they would buy that, and he could wear the mask to the interview with the detectives. Maybe that's why he did it. But his claim that he was in bed sick on the day of the homicide and whatever other days, it's inconsistent with what Dr. Bishop testified to. You heard her testify. He was administered treatment. His symptoms were reduced. He was able to be discharged, able to walk out of the hospital on his own. He was fine. He was able to drive. Dr. Bishop didn't prescribe him any medication. He wasn't in bed for 2 days. Simply wasn't true. And then, of course, you heard the testimony that the person driving the Charger from the murder scene just after the murder was seen wearing a mask. And you heard that testimony from Brittany Zeem. You heard the 911 call that was consistent with what she testified to. Now, she testified it was a yellow mask, but she wasn't completely sure of that. It's been 3 years. In the 911 call, she didn't give a color of the mask. It's possible she misremembered as far as the color, but the main point was it was a black male wearing a mask. And she described it as a surgical mask. Now I'm going to move on to the gun. So the .40 caliber Smith & Wesson, and Lisa Curtis gave that to the defendant because the defendant was claiming that there were some people who wanted to rough him up at his apartment, concerned about his safety. You heard testimony about that gun. Well, folks, that's the theme of our trial is technical difficulties. So I wasn't expecting that, but you saw the photograph of the gun. You saw that when Sergeant Russo testified, and he is able to observe that gun and was able to identify it roughly as a .40 caliber Smith & Wesson firearm. Now, if you could see the photo, you'd see there's no laser sight on it. That photo was taken just a couple days before Ms. Curtis had given the gun to the defendant. Ms. Curtis testified she didn't put a laser sight on it. You see there wasn't a laser sight on it. At the time of the homicide, or following the homicide, the Saginaw Police Department, and then later collected by the Michigan State Police, there was a laser sight right where the homicide had occurred. And then you heard the testimony, all the testimony about DNA that was sent to the lab compared with the defendant's sample. So you heard all that. Now, the testimony from Sergeant Rousseau was that the casings found at the murder scene, bullets found in the victim's clothes, Parham's clothes, when Sergeant Wenger transported Mr. Parham to the hospital, and when Mr. Parham was at the hospital. All that ballistics evidence, all that was consistent with being fired out of this type of firearm, 40 caliber Smith & Wesson. Not only that, all the bullets were found to be fired from the same weapon. All the casings were found to be fired from the same weapon. Now, there was also a fired bullet found in the defendant's residence. And now you wonder about that. Oh, that didn't match the ballistics at the murder scene. Clearly, the defendant had another gun in his house. Now, why didn't he use that weapon? And they didn't find the weapon there. Obviously, he got rid of it. He wanted to use a weapon that wasn't traceable to him. And that's why he asked for the gun from Miss Curtis. It wasn't that he was concerned about its safety. It was because he wanted to use it specifically to kill Parham, so that it couldn't be traced to him. And then he got rid of the weapon after he committed the murder. Defendant was asked about whether he owned a gun. And I'll just play you that portion of the interview instead of going through it myself.
Do you own any firearms? Are you allowed to own any firearms? Why not? What's that?
Allowed by who?
I don't know, that's why I'm asking.
You
You
a
shook your
felon?
head, you shook your head.
No, I don't know that.
So you can go out and buy a gun if you wanted to. Why not? You can have a gun registered to you, correct?
I don't know nothing about the gun.
Okay. So you don't have any firearms or anything?
So evasiveness. He didn't want to answer the question. He's trying to say, well, I'm not allowed to own firearms. So then I couldn't have had the murder weapon. But he didn't give her a specific reason. Now the DNA is consistent with, again, Thompson having been the shooter. And all the other evidence is consistent with it. Now, Mr. Farrell is gonna get up here and he's gonna tell you that Ms. Curtis isn't to be believed. He's gonna try and put Ms. Curtis on trial here. Ms. Curtis isn't on trial. Ms. Curtis was straightforward with you. She told you that she made a mistake when she was initially interviewed by the Saginaw Police Department. She was put in a difficult position by Mr. Thompson. Suddenly, she's confronted with Thompson using her gun, her car, and her son's phone to commit a murder. She had a strong relationship with Mr. Thompson. And that's why she didn't want to be the one to tell detectives what went down. You know, he brought Davion Thompson with her to the interview. She probably wanted him to confess on his own, man up, so she didn't have to be part of it. But she did tell the truth in the end, and she told the truth when she testified here. And I'm not going to go through this in depth because you heard a lot of technical testimony, but look at all the other evidence that corroborates Ms. Curtis. Again, the DNA evidence, ballistics evidence, Detective Kahn and the location of that phone. All this corroborates what Curtis said. The defendant told her that he committed the murder of Parham. That Thompson told Curtis that he used the .40 caliber Smith & Wesson. All that was corroborated. Because there's that man over there, Davion Thompson, that killed Antonio Parham January 27th, 2018 in Saginaw County, Michigan. Now you're going to be instructed at the end of this trial as to 4 counts. First count being you'll have the alternative to find the defendant guilty of first-degree murder or second-degree murder. Now, the evidence establishes both beyond a reasonable doubt. You heard the testimony from Dr. Varani that the cause of death was the 9 bullets that the defendant shot into Mr. Parham. It was the defendant's intent as clearly established through his actions, through the number of shots he took at the defendant, through the fact that he used a laser sight. He wanted to make sure he hit his target. His intent was to kill Mr. Parham. It's premeditated and deliberate. The defendant had planned this for some time. This was not a result. He didn't just get there and just out on a whim, split second, decide to shoot that gun 9 times. But even if you don't find first degree, it's clear that his intent was to murder Mr. Thompson or Mr. Parham. So you could find Mr. Thompson guilty of either. Defendant's also charged with 3 other counts: felony firearm, he used a firearm in murdering Mr. Parham, carrying a pistol with unlawful intent. His intent in carrying that .40 caliber was to kill Mr. Parham. And he carried a pistol in the vehicle unlawfully, and that was the pistol that he was driving to the 522 Bond address. So I'm going to ask you to consider all the evidence you've heard, and when you think about it and deliberate carefully, you're going to find that the defendant was guilty of all 4 of those counts.
Mr. O'Farrell, you may give your closing remarks.
Thank you, Your Honor. I don't know if it's better to speak from here or from the podium. It's a bit awkward. May it please the court, counsel, ladies and gentlemen of the jury. I haven't had much trouble with the audio visual in this case because I don't use it. But it's a little bit difficult to try to keep my notes together. This just isn't. I'll try to speak right into this. Now, you're not asked to leave your common sense at the door as you come here as jurors. Basically, the theory behind prosecution in this case is that Davion Thompson came up with an elaborate plan to identify Antonio Parham because Antonio Parham had killed his friend Brandon Pennywell, executed the plan by getting a car from Lisa Curtis, getting a gun from Lisa Curtis, and then manipulating communications with Mr. Parham to locate him and shoot him. But then that same smart guy, who according to the prosecutor's theory, takes the car back to the address, gets rid of the gun. When he's asked to go talk to the police by Lisa Curtis, says, the police want to talk to you. Okay. And walks into the police with her. And this guy who took all these steps to lure Mr. Parham into this and hide his identity and shoot him, walks into the police station wearing a mask. And he doesn't ask for a lawyer. He says, sure, I'll sign the form, I'll talk to you. I think common sense dictates you can't be smart and stupid at the same time. What's important to this case is there's somebody else in this picture. Exhibit number 1 in this case was the communications from Jamel to Lisa Curtis. Saying that he, Jamel, had paid 3 clucks and come up with the identification of Tone. Tone's the one who killed Brandon. And part of the communication of Exhibit 1 has Tone standing by his car with the January 24th date. This is right in that time frame. Tone gives the identification of the shooter to the mother of the deceased boy. She passes it on to the police. Detective Wortley is present and participates in the interview of Davion when he is in. That's the video that we saw. Besides Jacobs, it's Wortley who's there. Wortley's the one who Lisa sent the communications from Jamel too. Jamel is the one who had identified Tone and yet Detective Jacobs in this case says he's only seen exhibit number 1 for the second time here in court in front of you. Now, what about Jamel? And what about Davion? This wasn't the first son that Lisa Curtis had lost. She had twin boys. Brandon was killed in November of 17, but the year before, in 16, her other son was killed. And as she told you, Davion Thompson actually provided testimony in that case. Davion Thompson contributed to the killer of her first son being in prison. But the killer of her second son, they're twins, but Brandon's the second death, if it was Tone, is shot to death. Now, Lisa Curtis, during that time frame, was using prescription medications without having a prescription. There were 4 different medications. Lisa Curtis also testified that Brandon's car was at her apartment complex, and she let Davion use it so that he could go to a job interview. If Davion had been killed in November, and this is in January, the apartment complex is going to have some issues with you leaving an abandoned car. Remember, the detectives asked Davion, "Did you use her car?" "Yes." "Why?" "Because I was going to Jimmy John's for an interview. I called her to see if I had it." In his words, when asked, "Did she let you use it?" "Yeah." She said, "Everybody else is." And he picked the car up down in the South End, in the vicinity of Grant and Douglas Street, where he returned it. And that is a high crime, high drug use area. Now, the communication in Exhibit 1 is about clucks, and cluck cars can be drawn from that. You asked me, I questioned Detective Jacobs about clucks and cluck cars. So who had access and who actually drove the car on the 27th and used it to kill Antonio Parham? Lisa's at work. She doesn't know who parked the car back at her complex. There's no surveillance. Nobody checked to see if any of the neighbors happened to see it, even though the shooting occurs right around 12:30, and the car's located by a township police officer within an hour, 1:18. But nobody looks to ask who was driving the car. And the steps that are taken to hide the driving, the plate's taken off of it. The VIN is covered up. The only way that that car is identified is the police officer goes to the manager, who is able to say that that's Lisa's car. And then they can check and they locate it. The name Lisa clicks the bell right away because they're still investigating Brandon Pennywell's death. And that leads them right to the car, and it leads them right to Lisa within an hour. But there were efforts made to avoid that. Why? If Mr. Thompson was the one who returned it there, why go through that? Because he had borrowed the car from Lisa. She's not going to mention Jamel. When this first started, and she was interviewed on the 30th, there's 3 of her interviews that are kind of intermixed with the one interview of Davion when she brings him in to talk to the police wearing a mask. And in the first one, she says that Davion basically stole her gun. She had never gave the gun to Davion. And the police basically confront her. They say, look, we've got this word on the street that Antonio Parham killed your son, Brandon. We know it was your car. Your gun. You got to come clean. Exhibit number 1 came from Jamel. The detective says, we're going to have to bring Jamel into this. Right away, the first response is, that puts me at risk. Me and my daughter, who's 7, the last child I have left. Doesn't say anything about being afraid of Mr. Thompson, who testified concerning the death of her first son. In fact, brings Mr. Thompson in wearing the mask that leads to his arrest. But Jamel scares the hell out of her. And I asked her if she thought that Jamel meant for her to pass that information on to the police. And it continued to scare her. When she gives a subsequent statement, she says, oh yeah, and by the way, Davion admitted it to me. He told me that he had shot Antonio. And he did that right there in Don Pennywell's house, right there in the kitchen on Sunday night. He told me that. And Don and the other kid, Garland, were right there. And she described where they were in the room. And she was asked under oath on May 30th at the preliminary examination. Yeah, they'll back me. They heard the same thing. But no one came forward to say that. There's no corroboration. We had a trial in this case already. And in that trial, Lisa again confirmed that she was afraid of Jamel under oath. It was his name that came up, Jamel. The prosecution's theory here rests on her fear of Davion, which she's never voiced, and which has no reason really to be true. She keeps getting pushed into the corner. Her last story in this trial is that Davion called her shortly before the police. And that was the last communication on that phone. But that was a call. Someone canceled that call or the phone at 1:47 in the afternoon. Someone who had the information to do that. And Detective Khan said, not anybody can just call and cancel the phone. You've got to have the right information and give that to them, or the phone company won't honor it. And whoever did that executed it that way. And that information hadn't been changed from the time that the phone had been purchased. Now, Ms. Curtis says that not only did Davion admit to killing Antonio, but he also said, I got rid of the gun. But nobody got rid of the gun. The gun was canceled. The gun hasn't been introduced into evidence. It's who knows where it is. Jamel didn't leave that behind.
Objection, Your Honor. There's no basis for that conclusion.
This is argument. Counsel may proceed accordingly. The jury will use their memory to determine what the evidence was during the trial. Proceed.
Thank you. Now, Lisa Curtis also testified as to Davion that he knew where Antonio lived. He knew where he was. And this is where we get into some of these phone communications. And I myself don't have a good understanding, but for purposes of communicating here, I think we need to make the distinction between text communication and verbal communication. I don't text. But verbal communication using a phone is talking to each other. Texting communication, as I'm going to use it, is communicating back and forth. And the reason it makes a difference is because, as we found out from the testimony of Detective Khan, every time there's a text, it's counted as one contact. In other words, if I say hello and you say hello, that's two communications. Whereas in a phone conversation, it's 1 second. And the police, luckily, got not just the numbers of calls and the exchanges, which we have from Detective Khan, but the actual content through Cellbrate of those communications you have from the 21st, the 22nd, and the 27th. And the prosecutor tells you that that proves that Davion is the killer. But Davion goes in and talks to the police and tells them, yeah, I talked to Antonio. When I say talked, it's actually a text. And the communications went back and forth, and he says, I thought it was, I think it's 16th and 17th. When they get the actual cell, and Sobolewski talked about extracting the data from the phones, and then Cellbrite is how you get the data. And then it finally was recorded and read into the record, everything, that complete communications of those phone calls, text messages on the 21st and 22nd. And the prosecutor says, well, he's lying. He said the 16th. Well, on the 22nd, or on the 21st, they started around 10 something in the morning or something like that. And you get those communications basically touching base, talking about some marijuana and hooking up to maybe smoke a joint or whatever. That's what it comes down to. And they're going back and forth about that, and it goes on, and the communications continue into the afternoon. And they're talking about meeting up, and they're talking about Bloomy, the old area, which is true. Mr. Thompson, Davion, had said, hey, I've known this guy since we were kids. That's all part of the communication. He called me out of the blue. We talked about smoking a joint. Then I said, well, I sort of said, yeah, we're going to do it, but I didn't really want to do it. I didn't really mean to. Didn't intend to. And then it's actually within 24 hours, because the next morning on the 22nd, those phone calls are at 7 something in the morning. They last about 18 minutes. And when I say phone calls, it's texts. That's the time period. So this all occurs within 24 hours. Excuse me. Now, the other thing, as Davion was talking to me, he says, you know, I think I was sick. I was getting sick, which is even more consistent. He's accused of lying when he talks about the 16th, but if he was getting sick, maybe it could have been the 21st. Does that make him a murderer because he's mistaken about the date of the communication when he walks in and tells the police all about the communication? But then when we get to the 27th, whoever had that phone on the 27th is basically stalking Antonio Parham. The communications, back and forth, I got some dope, got wheels, let's smoke. Where you at? Where you at? Finally gets it pinned down to the 522 as he approaches that location. Finally gets there and does the shooting. But that's where we have the question of who is the shooter. That's where this business of the phone associated with Mr. Thompson, or was it Mr. Thompson? You heard the testimony of Detective Kahn, who knows more about cell phones than I ever want to, and can tell you in detail all of the statistical breakdown and his opinion about what's going back and forth. And I was thrown off when he talked about the 21st and 22nd in his analysis, showing like 40 some on one day and 20 some on the second day. I'm thinking it's two communications, but it's all this counting of this text messages that adds up to those numbers. And that's what leads to the conclusion about the same user over a 2-month period of time. But we're talking about a very low window on the 26th and 27th, and the calls being consistent during that time. And Detective Kahn is very honest when he's asked the direct question, can you tell who was using that phone on the 27th? No, I can't. If he can't be certain about it, the prosecutor can't, and neither can you as jurors extract more from a witness than what that witness testifies themselves. So think about the confrontation of Detective Jacobs towards the end of the interview of Davion. Because there's a point in that interview when Detective Jacobs kind of goes on the muscle and says, look, this is what we know. We've got eyewitnesses. We've got cameras. We've got fingerprints. We've got DNA. Everything says it was you. We know it was you. Here's your chance to say, well, was this guy, was Antonio threatening you? Were you trying to just protect yourself? And you can see in the video and hear in the voice that Davion is confused. There's a reason for that. Instead of saying all this evidence says I did it and confessing, he never does confess for the simple reason that he didn't do it. How do we know that? Well, we have one eyewitness who gave a description of a black male driving the vehicle, lighter skinned, and wearing a yellow mask. She herself, you'll recall, was wearing a blue mask. When I questioned her about her memory, I said, you're wearing a blue one. She says, oh, that one was yellow. Prosecutor says, well, maybe she doesn't remember. Well, they would like her to be wrong or testify that it was blue. That's their only excuse. Why? Because they seized the mask that Davion was wearing when he came in, which was blue, and they seized two masks at his house, which were blue, which is inconsistent with the shooter who was driving the car and shot Antonio Parham. It's also inconsistent with the testimony of Lisa Curtis that Davion knew exactly where Antonio Parham lived, but we've got those text messages stalking Antonio Parham. It's also inconsistent if we look at the bullet evidence. It's absolutely clear, I would suggest, from the evidence that that Charger and the driver of the Charger shot and killed Antonio Parham using the same gun, and that gun was a Smith & Wesson, which has tool mark characteristics, which were identified by Russo. There's no question that all of those casings that were recovered were fired from the same gun. Because of the special tool marks, it's very likely, and I don't question it, that the bullets that were recovered in the area were from the same gun. And the police search Davion's house on February 1st, and they find a bullet. Further evidence about the gun. They don't get it examined till after we've had the first trial. It's in that second batch, late in 2019, and lo and behold, all of those other casings come back just as they thought and just as we think. It was whoever was driving that Dodge Charger that stalked and killed Antonio Parham. But the bullet that was found in the house of Davion Thompson That was from a different gun. And while Brittany may have been mistaken about a yellow mask being different from her own blue mask she was wearing in front of you, she may have been. Detective Russo is not mistaken at all that it was a different gun that fired that bullet. So the prosecutor gives you an explanation that, well, he wasn't going to use his own gun, and so he got Lisa's so he could keep it a secret or somehow hide things. But using Lisa's gun led directly to the identification. Using a different gun from the mother of the person who the victim is supposed to have shot would give you a much greater chance. And the prosecutor says, even though they're searching the house, of course, they don't find no gun. And in his statement, Davion, when he talked to the police voluntarily, says, I don't have a gun. Prosecutor tells you, well, he got rid of it. This imaginary gun that would have been a much better weapon to use against Parham. Well, Davion pretended to be sick so he could get masks. He was diagnosed in the hospital records with mononucleosis. He went in late on the night of the 25th and got out in the early morning of the 26th. The homicide occurs on the afternoon of the 27th. When Davion is interviewed by the police, if you want to go back and hear it, he had a new phone number. It's not the phone number that the police are using in all of these phone call records. He had a new phone. Lisa Curtis had testified consistently up until this trial that he had lost his phone. She had tried to reach him. She couldn't. She was trying to reach him before the homicide. She changed her story in this trial. She was asked, I said, now you're saying that he lost his phone and he told you when you're taking him to the police station, tell him I lost my phone. Yes, that's what I'm saying. That's what she told you folks. But then she admitted that she said differently that he had lost his phone. She was contacting him on Facebook because he didn't have his phone before this shooting, and he thought he had lost it at the hospital or his doctor's office. I'll give you one characteristic of lost things. You don't know where they are or where you lost them. If you knew where you lost it, you'd find it. So he's guessing where he lost it because it's lost. The key is when. In her statements, Lisa admitted in each of her statements and prior, when she was under oath on May 30th, and again when she was under oath in September of 19, but she never said any differently. Those testimonies under oath are actually evidence in this case. The judge will give you an instruction about prior inconsistent statements. Part of the judging of the credibility of people. And of course, listen to the judge. If I misstate what the instruction is, take the instruction of the judge. But if someone gives a statement when they're under oath, it can be considered as evidence in this case. And other statements that are inconsistent, like in her statement to police and so forth that are not under oath can still be considered about whether or not she's telling the truth. Part of your consideration of whether she's telling the truth will be made easy because she said she lied to the police. She said she lied. When the prosecutor talks about her having been mistaken, no, even she doesn't argue that. And you could say, well, why would she lie about Davion, who was friends with her son? Why would she have a grudge against Davion? What's her motivation? It's not against Davion. It's fear of Jamel. As she indicated when first told by the police, we're going to have to drag Jamel into this. No, that puts me at risk. I have a daughter who's 7. The same thing she indicated in the first trial. It's only in this trial when she sat there and said, I'm not afraid of Jamel. Now we have DNA evidence that talks about the DNA of Davion being on that gun site. He's a donor of it. It's true. And the prosecutor gets into this 1 quintillion or whatever it is. But neither expert in this case said that that is evidence that you can consider that proves that Davion even ever touched that object. There's different ways for transfer. With a small sample, it may be more or less likely, but both experts would not follow through to say that that's evidence that he touched it. At most, it's consistent. It doesn't prove that he didn't, so it's consistent with that he did. The same with the phone calls from Detective Kahn. The user of the phone is consistent with being the same person all the way through the 2 months, but it doesn't prove it. He can't say who was using the phone on the 27th. So what's critical in this case is that on the 27th, the person who needed the location of Antonio Parham and got it is the person who is the shooter. But for all of those reasons, there's doubt, there's inconsistency, there's a lack of evidence that would prove that Davion Thompson was the shooter on that afternoon. Just his sickness. He was in the hospital emergency room, and the prosecutor says, well, he walked away. He was just there, I don't know, visiting, I guess. But you know, the way it works, if you don't meet the criteria for being admitted to a hospital, they let you go. And he didn't meet the criteria for being admitted. But he had his secondary asthma as well. And you were able to see him on the 31st when he's being interviewed and wearing that mask and coughing, and I won't go into any more. Is that the guy who had this elaborate plan and executed it? Possibly. That's a word the prosecutors used often. Possibly Brittany's mistaken. Or would it be consistent with some of the evidence? It could be. I believe, and I'm the lawyer for Davion, I believe the evidence absolutely establishes he's innocent. But my belief doesn't mean diddly. It's the belief of you folks as jurors. And here the law steps in, and the judge will be instructing you before too long. And again, if I misstate anything, obviously listen to the judge. But the only thing that you as jurors need to address these inconsistencies, this lack of evidence, is whether it establishes a reasonable doubt. I don't have to prove Davion is innocent. In fact, the law is the exact opposite. The prosecutor has to prove his guilt beyond a reasonable doubt. If I'm convinced he's innocent, if you have a doubt about his guilt based upon reason and common sense, then the verdict in this case is not guilty. It doesn't help Antonio Parham to convict the wrong man. This investigation was over as soon as Antonio walked into the, as soon as Davion walked into the police station wearing a mask. There hasn't been anything done since. The investigation into Jamel, it's only the second time it's been looked at. The lack of investigation, the cost of doing tests that would be too much. All of those things contribute to the conclusion in this case that there's something we don't know. The jigsaw puzzle isn't complete. There's too much there that's unanswered. There's too much speculation, too many conclusions to which you must jump to be able to convict Davion Thompson of the murder of Antonio Parham. You're not asked to be sleuths. You're not asked to be investigators. You're asked only to judge this case on the basis of the evidence that's been brought to you. And apply your common sense and judge the evidence. One thing that is normal for me here is that I draw to a close it makes me pause because I know as soon as I sit down, I'm going to think of something else I should have told you or tried to raise to you. Because when I finish, the prosecutor will be talking to you for the last time, and then the judge will instruct you on the law, and you'll do your deliberations. I've tried to do the best I can, but I'm human. But I do want to thank you on behalf of Davion and myself. Under these novel conditions and with everything that we have to deal with the distractions, I do believe that you're going to be fair. I do believe that you will apply the law as the judge gives it to you. And I do believe you'll reach the proper verdict in this case, and we thank you for your efforts in this case.
Ladies and gentlemen, we're going to take a short recess. When we return, the prosecutor will give any rebuttal remarks. I will instruct you on the law, and then we'll let you go to lunch, all right? So if you can hold on for another 40 minutes or so, or hour, I would guess, you can go to lunch. Is that okay with everyone? Anybody having pressing matters at noon you need to get to right now? No. All right, we'll take a short recess and resume with those arguments. Please be seated. Records reflect the jury is not present at this time. Anything with the record, Mr. Fedora?
I do, Your Honor. I'm just gonna wait a minute. I want to make sure the jury doesn't hear.
The jury's gone.
Okay, all right. So in Mr. O'Farrell's closing, he indicated that his client did not exercise his right to remain silent or ask for a lawyer, and he actually did that in the interview. We cut that off. So my concern is as far as that argument misstated the evidence.
Not in evidence.
Well, the evidence didn't show that part of it, so. And also what the lawyers say, once again, is not evidence.
And I'll leave it at that. That's a concern of mine.
Okay, what do you want the court to do about that?
I'm just making a record.
Okay, anything else,
No, Your Honor.
Mr. O'Farrell?
Just one thing, Your Honor. The prosecutor made an appointment or a point of playing the portion of the audio of my client's statement about whether or not he could own a gun. And that had been kind of skipped through 42 minutes, but to highlight that and then argue to the jury that he was being evasive obviously raises the question about whether he was allowed to have a gun because of a prior felony. It wasn't put into so many words, but I have no other reason why the prosecutor would highlight and present that as one of the excerpts from the statement. And I object to that, Judge. At this point, as far as a remedy, I'd have to think about whether I would request a specific instruction if the court would grant it or if the court considers it to have been error. But that's the issue I'm raising, Judge.
All right, well, let me put that one to rest for you in the court's opinion, Mr. O'Farrell. Your client also testified something about his being age of 20 and didn't think he could purchase a gun because of that. And so the jury can draw from that conclusion whatever they want to. I don't know why the prosecutor presented that particular piece of evidence either, but it was evidence because it was a statement of your client. So that's the court's opinion on your concern about that, Mr. O'Farrell. Anything else, gentlemen?
No, Your Honor.
Is it true you have to be 20 to buy a gun?
I don't know if it's true or not, but that's what your client told him. So,
I didn't know that.
I didn't either, but that's what he told him. Mr. Fedora, how long do you intend to do your rebuttal argument?
Within half an hour, I'm not sure.
Okay, I'm gonna say within 20 minutes. Okay? They've heard enough.
Okay.
All right?
Okay.
We'll take a break. amount of time, we can bring the jury back in. Is that correct, gentlemen?
Nothing from the people.
You're correct, Judge.
All right. Please be seated. Mr. Fedoruk, you may begin with your rebuttal remarks.
Now, I'm just going to respond to some of the things that Mr. O'Farrell brought up in his closing. Now, before I do that, I just want to start by saying what you heard as far as testimony and what you got as far as physical exhibits, what you saw, that's the evidence in this case. What I'm telling you, what Mr. O'Farrell is telling you in closing arguments, that's not the evidence. What you're looking at here is you're applying reasonableness. The burden that the people have in this case is beyond a reasonable doubt. And I accept that burden. It's not beyond any doubt. It's a reasonable doubt. Now, saying that, Mr. O'Farrell threw a lot of stuff at you. And what I'm asking you to do is look at the evidence. What does the evidence tell you? And these elaborate theories, is there any basis to them? There's overwhelming evidence here. The defendant was the one who killed Mr. Parham. Now, I'm not going to respond to everything he said. But here's the thing. There was a lot of people that were friends of Brandon Pennywell that were trying to figure out who killed him. What did the evidence tell you? The evidence tells you it's Davion Thompson that killed Parham. Now, the police didn't have to go and investigate every single person who gave Lisa Curtis some information. They had to put this case together as you heard it. Statements the defendant made. Ballistics evidence at the scene. What eyewitnesses saw. The defendant having the charger for that week. Him communicating with Parham with that phone. The defendant using the gun that he got from Curtis to shoot Parham. Now, Mr. O'Farrell brought up that the defendant provided a different phone number than the one that's in the text messages, than the one that Ms. Curtis had been communicating with Thompson through. Now, Obviously, he ditched the phone after the murder. So he probably went out and got a new phone number. But look at what else he said in that interview. When he was talking about that communication that we now know is January 21st, but he misrepresented to be January 16th or 17th. When he was talking about that communication, he said that he didn't have Parham's number. And he said that he didn't call him, he was communicating by Facebook Messenger. That's what he said in the statement. But we see in the evidence he was texting. So this was the phone that the defendant was using and sending text messages from that phone to Parham's phone. Now, what do you need to send that message to Parham? You need his phone number. So obviously he wasn't telling the truth about that. He wasn't telling the truth about a lot of things when he talked to Sergeant Jacobs. Now, counsel is basically acknowledging that it was the charger and it was the firearm that the defendant had that killed Mr. Parham. And again, all the other evidence puts that together for you. Don't look at everything in a vacuum. Don't just look at DNA evidence and say, well, you know, it's possible that, you know, this happened and this happened. Well, what's reasonable first of all? 1 octillion, 27 zeros. What's reasonable here? But look at that DNA evidence along with everything else you have. Ms. Curtis's statements, the ballistics evidence. Were the defendant's statements reliable or credible? Ms. Curtis wanted the police to handle her son's murder. She didn't want someone else going out and continuing this cycle of violence. That's why she was cooperating with the Saginaw Police Department in Brandon's murder investigation. Mr. Thompson wasn't participating. Brandon's father, Donald Pennywell, he wasn't participating. It was Miss Curtis and nobody else was helping her out. Davion Thompson took it out on his own to take care of this. And he threw Curtis in and put her in this horrible situation. Davion Thompson is the murderer. Find him guilty.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as a law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence, by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. We should not use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide this case based on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, did the witness seem to have a good memory? C, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Did the witness seem to evade the questions or argue with the lawyers? D, did the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias, prejudice, or personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? G, in general, does the witness have any special reason to tell the truth or any special reason to lie? H, all in all, how reasonable does the witness's testimony seem? When you think about all the evidence in the case, sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The prosecution has introduced evidence of statements that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person coming from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, a witness or witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial that was not under oath, only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statements were made under oath, then you may also consider the earlier statements as evidence of the truth of what the witness said in the earlier statements when determining the facts of this case. You may consider whether the defendant had a reason to commit the alleged crimes, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crimes. He only has to show that the defendant actually committed the crimes and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or any other facts and circumstances in evidence. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You've heard testimony from 6 witnesses, namely Dr. Kanu Varani, who was giving you his opinion as an expert in the field of forensic pathology. Dr. Caitlin Bishop, who was giving you her opinion as an expert in the field of emergency medicine. Nicole Graham, who was giving you her opinion as an expert in forensic DNA analysis. Grell Rousseau, who was giving you his opinion as an expert in the field of firearm and tool mark identification and gunshot residue. Randy Kahn, who was giving you his opinion in the field of cell phone technology, cell phone records and analysis, and mapping and plotting. And Julie Howenstein, who was giving you her opinion as an expert in the forensic DNA analysis. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts the expert gave for the opinion, and whether those facts are true. You should also think about the expert's qualifications and whether the expert's opinions make sense when you think about the other evidence in the case. You've heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, the defendant is charged with open murder. Under this count, you should first consider the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Antonio Parham. That is, that Antonio Parham died as a result of being shot by the defendant. Second, that the defendant intended to kill Antonio Parham. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. Under count one, you may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Antonio Parham. That is, that Antonio Parham died as a result of being shot by the defendant. Second, that the defendant had one of these three states of mind. He intended to kill, or intended to do great bodily harm to Antonio Parham, or knowingly created a very high risk of death or great bodily harm, knowing the death of such harm would be the likely result of his actions. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. It may infer that the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer that the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. Premeditation and deliberation may be inferred from any actions of the defendant, which show planning, or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of motive in deciding whether there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. In count three, the defendant is charged with the crime of going armed with a dangerous weapon with unlawful intent. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that the defendant went armed with a pistol. Second, at that time, the defendant intended to use this weapon unlawfully against someone else. In count two and count four, the defendant is also charged with a separate crime of possessing a firearm at the time he committed another crime. This crime is also known as felony firearm. To prove these charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, as to count two, that the defendant committed the crime of first-degree premeditated murder or second-degree murder. As to count four, that the defendant committed the crime of going armed with a dangerous weapon with unlawful intent. These underlying crimes have been previously defined for you in other instructions. It is not necessary, however, that the defendant be convicted of the underlying crime. Second, at the time the defendant committed that crime, he knowingly carried or possessed a firearm. A pistol is a firearm. Possession does not mean ownership. Possession means that either the person has actual physical control of the thing, as I do the pen I'm now holding, or the person knows the location of the firearm and has reasonable access to it. Possession may be so where one person alone possesses the firearm. Possession may be joint where two or more people share possession. In count five, the defendant is charged with the crime of carrying a pistol in a vehicle. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that a pistol was in a vehicle that the defendant was in. Second, that the defendant knew the pistol was there. Third, that the defendant took part in carrying or keeping the pistol in the vehicle. The prosecutor must also prove beyond a reasonable doubt that the crimes occurred on or about January 27, 2018, within Saginaw County. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, None of you should give up your honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Under count one, there are two different crimes that you may consider. When you discuss count one, you must consider the crime of first-degree premeditated murder first. If you all agree that the defendant is guilty of that crime, you may stop your discussions and return your verdict on count one. If you believe the defendant is not guilty of first-degree premeditated murder, or if you cannot agree about that crime, you should consider the less serious crime of second-degree murder. You decide how long to spend on first-degree premeditated murder before discussing second-degree murder. You could go back to first-degree murder after discussing second-degree murder if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The defendant is charged with 5 counts. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all the evidence in the case. You may find the defendant guilty of all or any of these crimes, guilty of less serious crimes, or not guilty. I've also prepared a verdict form listing your possible verdicts in this case. In count one, you will see that it's a charge of open murder. Your possible verdicts are not guilty, guilty of first-degree premeditated murder, guilty of second-degree murder. Once you reach a verdict on this, your foreperson will sign and date the verdict form. Count two charges the defendant with felony firearm, underlying felony being first-degree premeditated murder or second-degree murder. Once again, your options are not guilty or guilty of felony firearm. Once you reach a verdict, your foreperson will sign and date the verdict form. Count three says, charge the defendant with going armed with a dangerous weapon with unlawful intent. Your possible verdicts are not guilty or guilty of going armed with a dangerous weapon with unlawful intent. Once again, your foreperson will sign and date the verdict form. Count four, charge the defendant with felony firearm, underlying felony being going armed with a dangerous weapon with unlawful intent. Your possible verdicts are not guilty or guilty. And count five, charge the defendant with carrying a pistol in a vehicle. Your possible verdicts are not guilty or guilty. Once you reach a verdict, your foreperson will sign and date the verdict form. I would like to see counsel at the bench, please. Formal instructions at this time, and we will now reduce the number of jurors who hear this case by 2. If your name is called, please just remain seated for now. Okay. Juror number 8, Ms. Milburn, just remain seated for now, though. And juror number 7, Ms. Gunther. So Ms. Gunther and Ms. Milburn, even though you've been excused at this time, I will still ask you not to discuss the case with anyone, to let them discuss with you, because you're alternate jurors. And should something develop where you need to be coming back as jurors to deliberate, we want you to still be fair and impartial, all right? So even though you've been excused at this time, still don't discuss the case with anyone or watch any news reports as well. All right? And now you can administer the oath of office to the, I'm sorry, oath of deliberation for the jurors. You can use that microphone there too, possibly. I think it's on right here. You can all be seated at this time. Now administer the oath to the law clerk. And at this time, ladies and gentlemen, we are going to break for lunch, as I indicated. It's about 10 to 1. I'd like you to come back at 2 o'clock to begin your deliberations, and I don't want you to begin deliberations so all jurors are present, okay? So at this time, I'm going to excuse you. Have a pleasant lunch. We'll see you back at 2 p.m. You may be seated. Record should reflect the jury is not present at this time, and after the court had read instructions, I had counsel approach the bench for any additions, deletions, objections, or corrections. Mr. Fedork, I believe you had none.
Correct.
Mr. O'Farrell, I believe you had none.
That's correct, Judge.
Anything else for the record, Mr. Fedork?
No, Your Honor.
Anything else, Mr. O'Farrell?
No, Your Honor.
We will stand on recess until 2 p.m., gentlemen.
Judge, you want us back here at 2 or just by available?
If you're not going to be back here, be where we can reach you by telephone, Mr. O'Farrell
Thank you,
or
Your Honor.
Mr. Fedork.
Am I okay going back to the office?
Yes, just so we can reach you both, that'll be fine.